Welcome to our first hour of Court TV Live. I'm Julie Grant. This hour, we are in the state of Florida. We're covering a case against a defendant, Jacob Cannon. Let's take a look at the background of how we got here at this point in the case.
I'm going as hard as I can. Deal with it. That's not my fault, you can't You're almost done. You're almost done. That's enough. I'm done. Either you take me to go piss, or you no, take me.
So this former police officer, Jacob Cannon, pleaded no contest for that moment we just saw there as he was arresting that woman in Florida. And today, he's going to be sentenced for that crime. He's looking at potentially prison time. And let's take a listen to what his attorney and the prosecutor said as they were arguing about the potential sentence that he should receive.
Regarding any departure, it is I just want to make sure I got this right, that they are moving for departure pursuant to an isolated, unsophisticated event for which he shows remorse, and that he's amenable to treatment. Specifically, I think the anger management, I'll let them put that on the record, that he's amenable to treatment. And for those two reasons, they are saying that they are able to, Your Honor would be able to depart if Your Honor put the victim injury points on there.
My understanding was, in addition to those two, there was mention that I should consider the behavior of the victim, which could potentially go to a third grounds for downward departure.
So, and that's what I'd like for the defense to clarify, Judge. They made an argument about that. I don't know, and perhaps they can point out what evidence they have of that and what case law would support that. The state objects to that. I believe Your Honor can depart pursuant to isolated, unsophisticated, for which he shows remorse. Again, we object to a departure that you should not depart. I believe that you can depart pursuant to that he is amenable to treatment. However, I object to that. I don't think that you should depart for all of the reasons that I stated on Friday in my argument. Pursuant to that last litigator, if that's what they're arguing, I disagree. I do not think, number one, that there's competent substantial evidence of that, and number two, I do not think that there's case law that supports that. So I don't think that that's a ground for departure.
Okay, thank you, ma'am.
And the last thing, Judge, they had kind of insinuated, there's no evidence of this, but insinuated an argument that Mr. Cannon was not receiving proper medical care in the jail. He had been there about 2-3 days on Friday when they addressed that. I'll let them address that and I can rebut that if needed. But again, I don't know if that's a movement for some sort of departure or what exactly the purpose of that argument is. But if it was something for departure, there would need to be actual evidence of that on the record that I would then rebut.
Okay. All right, Mr. Lambert.
Good morning, Your Honor. Yes, it is that he is one of the reasons that he's amenable to treatment and that they don't offer that specialized treatment in the prison. They only offer it outside. One of the downward departure reasons that treatment would be for mental health, not just anger management. The either explosive disorder or PTSD, depending on what they end up figuring out the mental health issue is. So yes, that is one of the reasons that she instigated. With regard to the slight evidence on that, that's all in the medical records that the court reviewed in the videos. It's just that attitude. It's not something that we're doubling down on, just pointing out. With regard to the case law and the points, Judge, the Lynn v. State case, Lynn had told the officer that he bit that he was HIV positive. That caused a huge issue with his mental health, with his family's health, with all of it. So it's kind of disingenuous to use that case as a comparator, but we do agree that it is within the court's discretion, but we do not believe it's moderate. But even so, the state does it sounds like the state agrees that there is a reason the court can downwardly depart if the court chooses to downwardly depart. So we would ask the court to downwardly depart and make it a treatment-based probation where he can get the help he needs. Thank you, Judge.
All right, so this was bad. This incident was bad, and let's talk about it, and let's take a look at it again. I want to bring in our guest. He is an attorney in private practice now. He used to head up the homicide unit in Norfolk County, Massachusetts. Rick Grundy is our legal analyst this morning. Rick, good morning. I want to play that clip again for you, and we'll get some analysis on the other side. So this is a DUI arrest. This officer was trying to have this suspect undergo a breathalyzer test, and things go really, really bad. Let's watch.
I'm blowing as hard as I can. Deal with it. Well, that's not my fault, but you can't your You're almost done. You're almost done. That's enough. I'm done. Either you take me to go piss, or you no, take me.
Oh my, Rick Grundy, your thoughts on that, please.
Well, number one, if you're looking to go into a job where you're going to have pleasant interactions and develop relationships with the general public, don't go become a police officer. So that sheds the light on, and I don't know anything more about this officer, this department, training, whatever, but imagine this person put in a situation of true confrontation requiring de-escalation. This is a situation where you have a highly inebriated person in handcuffs, in custody, with another officer there. There's certainly no question that this officer is in any kind of fear or anything. And you have to look at this and think that with any form of proper training that includes extensive psychological testing, extensive training, an extensive probationary period with a seasoned officer where you're out on the street and have these situations and are confronting them with the proper guidance, that this would happen. I think the statute of limitations have all gone. So I will tell you that as a prosecutor, the first time I tried my first case, I said to the police officer, "You're the first police officer I got to know that didn't have to chase me first." Police officers, I grew up in Newark, New Jersey. It was a tough town, and we respected police officers, but at that point in time, we also had a fear of police officers because we knew how things were handled there. We've come a long, long way from there. And what we've learned is that the respect that police officers are due and need to have in order to do their job is something that cannot be rooted in fear. In fact, it's not true respect if it's rooted in fear, and it doesn't work, whether it be a parent, a teacher, or a police officer. And this individual, I just think I can't look at this and think this is the first sign of this. This is the first time these events, these type of signs have come out on this person. Quite frankly, if I were the judge, I would have said to counsel and the defendant, I don't accept your no contest. You'll stand before me. You'll admit that you're guilty of the charges, or you'll face a jury.
Excellent analysis, Rick. I really appreciate all the comments you made here. And yeah, as to your last comment, talk about that legally, if you would, please. The judge doesn't have to accept that no contest plea, right?
Correct. Now, that could be jurisdictional, state by state. I can tell you, I've practiced in 6 states. I've had two trial, and all of them give the court the opportunity to reject a no contest plea. And I just think in a situation like this, I don't know what the PTSD claim is grounded in. If he's a combat veteran, I give all respect for that service. But again, this is not a confrontational situation. In a situation like this, as a judge, I would not accept a plea from a person who is standing before me saying, look, you could probably find me guilty, but I don't have the wherewithal, the appreciation for what I've done to stand before the court at this late date and say, I was wrong and take full responsibility for my actions.
Mm-hmm. Right, Rick. Yeah, I mean, this is really bad for so many reasons. I mean, there wasn't prior aggression from her. Oftentimes we see officers get into altercations because a suspect takes a swing or there's something. Here, she's cuffed. So she's a detainee who's cuffed, also very drunk, as it appears from the video. And this was, appeared to be unprovoked by anything other than maybe something verbal. I mean, just terrible. I wonder what happens to his career. And to full disclosure here, the sentencing happened on Tuesday, so we're going back a bit because we've had so much going on in terms of other trials. We haven't been able to show it. But Rick, do you think, is he done? I mean, I would think he's got to be done after this. What do you think?
I would certainly hope so, and I know situations where officers have gotten into these types of matters and they go on a job search and they'll go nationwide. And oftentimes they'll find a small department somewhere in the country that will take them on and give them another shot at it. One of the things when you say the consequences of this that I noticed, and is just a bugaboo of mine, is that he resigned from his position. Now, a lot of times, and when I was head of the criminal bureau at the Attorney General's office in Massachusetts, we handled a lot of police misconduct cases involving violence. They resign in order to protect their retirement as opposed to being fired. Right. So I question whether this department is allowing that. My opinion, the department in a situation like this, you can send in all your letters of resignation you care to, but I want it on your record, and I want it for the taxpayers of my jurisdiction to go down as you were fired. Well, a lot of times, unfortunately, with union issues in Massachusetts and other states, they'll accept the resignation because they don't want to have the 5 years of appeals.
Mm-hmm. Right, Rick. That's a really helpful point. This is a felony, too, as you know, Rick. For anybody wondering, he pleaded no contest to felony battery. So now he's got that. He's got a criminal record now. So really went on the other side of the law, as we say. Rick Grundy, I'm so glad you're here this morning. We'll hit a break. Stand by kindly, please. When we come back, we'll show you the key moments from the sentencing of this former officer in Florida.
Matriarch of the Adelson family gets arrested.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins this August on Court TV. Oh, the difference.
I've watched all of the videos. Ms. McRee was highly intoxicated. She was verbally abusive. But that's your job in law enforcement, to deal with all sorts of people, including people that are hostile, verbally abusive, and highly intoxicated.
There's the judge at the sentencing for former officer Jacob Cannon. So this case happened in Florida. He was an Ormond Beach police officer until an incident where he slammed a woman who was intoxicated and under arrest into a glass wall. It's all caught on video camera. He was doing it when he was trying to administer a breathalyzer test to that suspect. Her name is Shanna McRee. It happened last December. This guy pleaded no contest to felony battery. Take a look.
I'm going as hard as I can. Deal with it. That's not my fault, but you can't your You're almost done. You're almost done. That's enough. I'm done. Either you take me to go piss, or you no, take me.
Oh my. So this guy pleaded on Friday, was sentenced on Tuesday. So we're going back and watching what happened at the sentencing hearing. Take a listen to the judge.
Mr. Cannon, would you please stand up with your attorneys? So I do agree with the defense that permanent disfigurement doesn't always necessarily mean moderate injury. I don't find the Lynn case or the citing of the Lynn case by the state to be disingenuous. I think it is helpful. And in that case, the court pointed out that scarring, along with the potential HIV issue in that case, was enough for moderate injury points. And I do think moderate injury points are appropriate in this case here. And I think that that's within my sound discretion to decide. And the reason for that, the reason I'm making that decision is Ms. McRee has a 1.5 to 2 inch scar right across the center of her forehead. She had 7 stitches for that. And then I think we're 7 months after the injury when she sat here next to me, just a few feet away from me. It's glaringly obvious, and that's something she's going to have to live with unless she gets plastic surgery to get rid of it. But it's red, it's raised a bit, and it's readily available to anybody who looks at her, readily visible. So I am scoring the moderate injury points. That unfortunately means that the defendant scores 19.1 months DOC unless I find grounds to downward depart. Obviously, this is a tough case, and let's talk about the grounds for downward departure. And I saw Mr. Lambert nodding his head when I was saying that I thought one of the grounds was that the victim, Ms. McRee, was somehow an initiator or provoker of the injuries that were caused to her by the defendant. And I've watched all of the videos. Ms. McRee was highly intoxicated. She was verbally abusive. But that's your job in law enforcement, to deal with all sorts of people, including people that are hostile, verbally abusive, and highly intoxicated. She was, in fact, screaming and combative at the hospital and had to be given medication and restrained, as your attorney argued. That was after the injury, though, after she had lost a significant amount of blood and had this huge gash across her forehead. I don't find that there's grounds to downward depart. I don't think that that has been proven, and I don't think it would be appropriate even if it had been proven. Unlike the state, I don't think that this was committed in an unsophisticated manner. I do think it was an isolated incident, and the defendant showed remorse for it. But the reason I'm finding that it wasn't committed in an unsophisticated manner was because after the victim was injured, she was placed in a holding cell. I think ignored, as best I could tell. Nobody attempted to tend to her or give her any kind of aid. And then there were lies to the supervisor about how it occurred. So I don't find that that was committed in an unsophisticated manner. I do agree with the state, though. The defense has proven that the defendant suffers from a mental illness that's unrelated to substance abuse or addiction, and the defendant is amenable to treatment. One of the mental health providers, I think, saw the defendant, it looked like only one time, and diagnosed him with PTSD based solely on his 7 years in law enforcement. I'm disregarding that opinion. I think that that opinion it is not specific to the defendant. The other treatment was more ongoing. It started in January and continued through June. There was a diagnosis of intermittent explosive disorder, and I find that that is appropriate under the circumstances. I do find that you suffer from mental illness that's unrelated to substance abuse, that you are amenable to treatment. I am going to consider, in addition, your lack of any criminal history whatsoever in the 7 years of public service that you've done through your job. And I want to be very clear, I am not downward departing because you were a police officer. I am downward departing because you have no criminal history, and I'm trying to treat you the same as I would anybody else under similar circumstances in a similar situation. So I am going to adjudicate you guilty. The reason for that is, as a convicted felon, you will not be able to own a gun, buy a gun, and possess a gun, and that's important to my sentence. I'm going to sentence you to 6 months county jail. Madam Clerk, how much credit does he have?
He's got 11 days.
Okay, you have 11 days credit. That's going to be followed by 2 years of probation, during which time you need to undergo a mental health evaluation and any recommended treatment. You will be required to surrender your law enforcement certification to the state of Florida, but I believe you've already done that, sir. And then I am going to order restitution to the victim, Ms. McRee. I'm going to reserve for 60 days to determine that amount. And so if it wasn't already done, Madam Clerk, I'm going to revoke his bond today. And then the court costs are $770 plus 100 costs of prosecution, 100 costs of investigation, and that'll be a condition of your probation as well. Like I do with everybody else, I'm going to waive your cost of supervision for 1 of the 2 years of probation. And that's to encourage you to try to complete the terms of the probation and terminate early at that halfway point. Your attorney knows that you can file a notice of appeal within 30 days of me signing the judgment and sentence. And then the other thing I wanted to mention is that any of the items that were submitted and taken into evidence are public record currently, and defense may want to consider whether to seal the medical records. Okay. Anything else the court needs to address today?
No, Your Honor.
Okay. All right. Thank you, folks.
Thank you.
6 months in county for that former police officer. Let's get some reaction from our legal analyst guest, attorney Rick Grundy. Rick, even though it's county, not state prison, not going to be a picnic for this guy, is it?
No, not at all. I mean, he's going in one of the worst categories that you want to go into due time, and that is as a former police officer. I think it's an appropriate sentence. You know, the thing is, you never know. I don't know with respect to Florida on a county sentence. If he was in Massachusetts, he would be eligible for parole after serving just 50% of that. So if he's looking at doing 90 days and getting out, I think that's kind of light. But, you know, I'm assuming that we're looking at a person with no prior record. You know, all roads to law school for pretty much everybody start with avoiding mathematics. But if that's a 2-inch gash, I really did poorly in math, because that looked like a good 5 inches opened up there. So this was, and we see it. It's done with some force and some velocity. Now, one of the more interesting things I heard was with respect to his mental capacity, intermittent explosive, at least one other occasion of intermittent explosive violence. This gentleman's a police officer. That department assumingly knew that he had one prior, which is one far too many explosions of violence in some venue, whether it was on the job, off the job, we don't know. But I mean, the fact that he was given a second opportunity, and I'm not hearing anything about any kind of discipline, training, etc., that went forward after that, that's extremely troubling to me. And maybe that's where this could have been prevented. Secondly, I mentioned the PTSD earlier, and it turns out he was not a combat veteran. This was simply his 7 years on the force. If he's experiencing that as a police officer, again, people under the influence of drugs and alcohol is probably, and in a smaller jurisdiction even higher, 75% of what you're dealing with, whether it's in a traffic situation, whether it's in a domestic situation, whatever. If you can't keep it together for that, you cannot be in this job. And if you're experiencing PTSD at any point during those 7 years, you should have reported it. The job should have picked up on it, and you just should never have been in that room with that woman.
Mm-hmm. You're right, Rick. You're right. That was inexcusable what he did. And that woman with that awful scar on her face, I would be furious if I were her. Look at that. Here's another photo. So this was the mugshot because she was being processed at this time, getting the breathalyzer. She was under arrest for DUI, hadn't yet had the mug taken. And obviously they had to take her to get medical treatment first. You can see the stitches there in her face. She's, permanently disfigured because of this. Rick, I would have to think that this woman has a civil lawsuit she could bring as well. Would love to ask you about that, please.
Oh, the ears were perking up there, when they were mentioning the guy's background. Like I said, I just a little footnote too is that we saw in the first clip, we saw the defense do a little bit of a presentation with respect to downward departures and whatnot. I absolutely appreciate that. An attorney needs to at times get up there and through him show his client's contrition, his client's remorse, etc. There's a difference between that and just getting up there and saying, Judge, I just got to say something here. I'm just going to pick at a couple of threads as best I can, and I'm going to keep my own head down and kind of talk in a very low voice. I still got to advocate for the person there. But all of the things that were put out there in an effort to lessen that the criminal sentence, I do not think provide any doors of relief for him on a civil level. Again, we'd want to see what this other intermittent explosive violence action was prior to this. And of course, on the civil side, they're going to be looking for the deep pockets, which are likely not this officer, but the department. And we're going to want to open up that whole file. We want to see everything that's occurred over those past 7 years. And as I stated initially, I have a very difficult time thinking that this is the first time that this character trait was exhibited during those 7 years. My guess is that file is going to be chock full of civilian complaints, whether it's just verbal aggression, not ever laying hands on people, but a person who is becoming a bigger person behind their badge and their gun, and people feeling on the wrong end as a result of it.
Mm-hmm. Yeah, if it was, I see a complaint for failure to supervise. Rick Grundy, a great analysis from you as always. Let's leave this case here for now. As